Welcome to It Depends, a sales tax podcast by TaxConnex. I'm your host, Brian Greer, joined by my colleague, Jeff Meggs, and we're super excited that you've joined us today. Sales and use tax can be confusing and overwhelming, but it doesn't have to be. Whether you work in an industry or a CPA firm, or just someone who wants to stay informed about the latest sales tax laws, we've got you covered. Periodically, we'll explore different aspects of sales tax. So whether you're a tax pro or a novice, in industry, school, or a practicing CPA, tune in and join us as we attempt to simplify the complexity of the sales tax world. This is It Depends, because with sales tax, there's rarely just one answer, and often that's our answer to many questions. It just depends. This is Brian Greer. Nice to be with you guys here. I've got one of my partners, Jeff Meggs, with me as well. But just to provide you a little bit of background information on ourselves and our business before we get started, if you're not familiar with TaxConnex, we do specialize in the sales and use tax arena. I would consider us a professional services firm. We do have two primary service lines within our business. One is our consulting and advisory type of practice, and Jeff heads that up for us. But we help companies identify what their sales tax obligations are in context of marketplace facilitators, perhaps where they have nexus and a requirement to collect and remit on behalf of their third-party sellers. Those are common types of questions and issues that we address from a consulting advisory type of perspective. And then the second business line that we have is a compliance outsourcing service where we also step in and prepare and file sales tax returns and remit those on behalf of our clients. So again, focus very specifically in the sales and use tax arena. I'll kind of kick this off. We often like to start with some type of baseline foundation here. And from a sales and use tax perspective, that always starts with a little bit of a discussion on nexus and where you have a connection to a jurisdiction and thus where you might have a sales tax obligation. We'll also talk about the potential taxability, which is kind of the second building block from a sales tax perspective, along with that nexus piece. And then really segue into kind of the meat of the agenda. What defines a marketplace facilitator, and what are the requirements of the facilitator? And as a business owner, if you're leveraging a marketplace facilitator, what does that mean to you as well? And just highlight some issues that we've seen over the years. Personally, I've been in this for about 22 years or so, and Jeff's been at it a little bit over 30 years. Of course, the marketplace facilitator piece of this is a little bit newer, since over the last handful of years, but we'll certainly share some of our experiences along the way here as well.
Thanks, Brian. Yeah, nexus is sort of an industry term, I guess. Its meaning is it's really a connection. So the real, I guess, layman's term is, do I have a connection with a jurisdiction that would allow that jurisdiction to enforce their sales and use tax laws against my business? And as Brian said earlier, the starting point when we're looking at sales and use tax compliance is nexus. Do I have a connection? Do I have a presence within that jurisdiction? And a lot of times we're dealing with state level jurisdictions, so I'll kind of keep it at that level. But do I have a connection with that state that would allow that state to enforce its sales and use tax requirements on my business? Historically, when we've dealt with sales and use tax nexus, this goes all the way back to 1967. There was a case, National Bells Hess versus the state of Illinois, where National Bells Hess was a clothier who sent catalogs into the state of Illinois. Customers would obviously not go online to order, but would make phone calls. More often than not, they would just fill out an order form, mail it back to the vendor. order the clothes will get shipped to them. National Bell Test didn't have any physical activities located within the state of Illinois, except for the catalogs and except for the fact that they were generating business. The state of Illinois attempted to assert nexus in that case, and in doing so, basically said that the issuance distribution of those catalogs represented a physical presence on the part of National Bell Test. This kind of went up through the courts. The courts ultimately ruled in favor of National Bell Test and sort of set out the standards by which most companies have conformed for the better part of the last 50 years. And that was, there has to be more than an insignificant physical presence. A physical presence can be an employee, an office, a store. It could be inventory. And those are more permanent sort of descriptions or scenarios. There's also temporary presence by way of having employees visiting the state to solicit. There can also be sort of second degree presence, and that might be me leveraging a third-party service provider to execute on my behalf in a particular state on behalf of a particular customer. So there's a number of ways that physical presence can be established, and like I said, that's been the long-standing principle when it comes to sales tax nexus. 2018 brought us a whole new variable, another bright line test, and what happened in 2018, South Dakota had decided to legislate an economic nexus standard. And states had always been pushing the envelope and trying to get a broader application for purposes of nexus so that they could bring more revenue into their states and sort of encompass more business activities. And this is all driven by internet sales, as you might imagine. So South Dakota enacts this legislation, basically says if you have more than $100,000 in revenue in the state of South Dakota during a calendar year, or you have more than 200 transactions, you have a responsibility to register and comply with our sales and use tax laws. They deem that to be economic nexus. This went up to the state Supreme Court, and then interestingly, the state Supreme Court in South Dakota ruled that the law was unconstitutional and defeated the state. Wayfair is the name that's most associated with this case and this law, primarily because Wayfair, an online home goods retailer, was the first to formally challenge this principle, this legislation. And so Wayfair won at the state Supreme Court level in South Dakota. South Dakota then took it and asked for it to be heard at the U.S. Supreme Court level. And at that point, there were arguments heard, I think, in April of 2018. In June of 2018, the U.S. Supreme Court ruled in favor of the state of South Dakota, thereby basically qualifying that level of the legislation, that concept of economic nexus for sales tax purposes, and in doing so, opened the floodgates for all states to enact similar legislation. And as you might imagine, everybody was eager to jump on that bandwagon. So a lot of the states had already written their legislation, and they enacted it almost immediately upon the results of the U.S. Supreme Court. But over the course of, I'd say, a couple of years, different states went live with their legislation. So it did take a little bit of time for everybody to come on board. In fact, today there's the one lone state that has yet to go, what I would call go live formally, and that's Missouri. So Missouri has, in fact, approved and enacted legislation associated with an economic nexus standard for sales taxes, but its effective date is January 1, 2023. Every other state has enacted legislation, and it is active today. The way to think about economic standards and economic nexus, and what I tell our clients to do, is keep track of your total invoiced revenue by state. And over a 12-month period or during the course of a calendar year, if it exceeds $100,000, you need to drill down and evaluate whether or not you've triggered nexus in that state. Not all states are equal in this regard. There are nuances. The states of California and Texas have a $500,000 threshold. So until you reach $500,000 in a 12-month period in sales into those states, you're not considered to have established economic nexus. But the overwhelming majority of the states fit into that $100,000 range. And in addition, there's more than a handful of states that also have that 200 transactions. So it's an either or. You either have more than $100,000 in revenue, or you have more than 200 transactions. Keeping track of the transactions is a bit of a challenge for most people, and the reality becomes that if you're in excess of 200 transactions but you haven't reached $100,000, it still might not be material enough for you to take action. But in fact, you have established nexus, and the state is expecting you to comply with their tax laws. When we look at the states for purposes of sales tax, we're talking about every state in the union. We're talking about D.C. We treat D.C. as a state. They have their own administrative sales tax function. There are 5 states that kind of have exceptions to the rule. 4 of them, there is no sales tax in those states, and those states are Delaware, New Hampshire, Oregon, and Montana. The state of Alaska is also into that category. There is no state sales tax in the state of Alaska. However, there are cities within the state of Alaska that do have sales and use taxes, and those cities have come together, formed a coalition, and established their own economic nexus threshold. And it applies in a similar fashion. If you have more than $100,000 in sales into the state of Alaska, those cities within this coalition have the authority to impose their taxing requirements on you. So that's nexus in a nutshell. The evolution from physical to economic, while it's a change, it's an additive. They both exist. So you can still have nexus through physical means today, and you can also create nexus through economic means. The second piece of this equation, and it's important to look at these, the nexus piece and the taxability piece as separate pieces for purposes of compliance. Just because I have nexus in a jurisdiction or in a state does not necessarily mean I have a requirement to do anything for sales and use tax purposes. TaxConnex, our business here, is based in the Atlanta, Georgia area. We don't provide anything in the way of services or products that are taxable. So we're not required to be registered and file a sales and use tax return. This is true for a large portion of businesses across the country. So in addition to, and after we have established and identified which states in which we have nexus, we then have to ask the question, are we providing a taxable service? Are we selling tangible personal property or selling something that's taxable? And here again, most of the states are very similar. Most of the states sort of establish that there is a tax imposed on the retail sale of tangible personal property and enumerated services. So some services are taxable, some services aren't. There is quite a bit of differentiation between the states when it comes to the scope of services that are in fact considered taxable for sales tax purposes. But tangible personal property, the sale of which is historically always been sort of a standard, the starting point. And when we get into services, I do want to kind of talk a little bit about the term professional services. We talk to a lot of technology firms that are in the business of providing downloaded software or software as a service, and there's usually a vertical service associated with that, or an ancillary service. It could be configuration or implementation, it could be training, it could be consultation, could be custom programming. There's a tendency for those companies to characterize those ancillary services apart and separate from the software as quote unquote professional services. And professional services is sort of a dangerous term because it can be all encompassing to some people. The way I would describe it to you is professional services, in the way the states look at it, is primarily those services associated with things like lawyers, CPAs, doctors, engineers, architects, those kind of really certified and licensed service providers. That is what we like to put into that professional services category. Everything else, training, configuration of software, consulting, we call those services. We try to stay away from calling them professional services so that they don't get confused and lumped in with those other professional services that are almost always exempt. Some of the primary services that you will find are taxable in almost all states. Telecommunications. Telecommunication services are the most taxed services, I think, in all of the land. But there's a host of other services that states consider to be taxable. There's information services, there's data processing services. There's always, or sometimes, a question of whether or not the services are delivered in a tangible medium versus an electronic medium. And then the last piece of the equation, after you've kind of decided what is taxable and what's not taxable in a specific state, is situsing. Situsing is another critical component to the compliance process for sales tax. And that basically refers to where is the transaction sitused? Where has it occurred from the standpoint of sales tax applicability? Is it the customer's headquarters where I invoiced the customer? Is it the bill to address in that case? Or is it where I shipped the product? Or in the case of services, software as a service, I may sell a 100-seat software as a service license to a company in New York who might have 50 offices across the country and users located in each of those offices. So under those circumstances and conditions, where do I deem those transactions to be sitused for sales tax determination purposes? The general rule of thumb is ship to location, or in the case of services, where is the benefit of use? So if the benefit of use is spread out all over 50 states, the potential exists that you have a compliance responsibility in all those states to the extent you have nexus. So that's just sort of hopefully a quick overview of nexus and taxability. They have to meet together. They have to come together. You got to have nexus and a taxable event for there to be a need to comply.
Yeah, that's perfect. And I think it brings us to the what is a marketplace facilitator?
Yeah, so it's kind of interesting because there was a lot of noise around Amazon for over a decade. You know, the states were starting to attack them in the late 2000s, seeing those revenue switches or changes migrating from brick and mortar to online, and seeing scenarios where the shipments were originating from outside the states, and states were scared and fearful that they were losing their revenue base. Add to that the expansion of Amazon, and during this time frame, Amazon is building out their infrastructure. They're building warehousing. They're starting to settle in with inventory, mass quantities of inventories in a lot of states. And so there was this evolution, and there was an Amazon law that it was referred to as the Amazon law, but it was really more like just an internet transaction law. And so there was this evolution that talked about transactions that are connected to a website or web owner that has a physical presence in that particular state. Those transactions that flowed through that web owner would in fact become taxable. And what ultimately that led to, as we got past the Wayfair decision, was the term marketplace facilitator. And this term is used really similarly throughout all the states. The states have now adopted, and all of the states have adopted, a marketplace facilitator rule on the heels of the Wayfair decision. So it is another step along the pathway of economic nexus. A marketplace facilitator, as we see it defined by almost all the states, is a third party that is establishing or making available to the market a platform on which purchases can be made, and this is really critical, it has to be, and there is acceptance of payment. There is processing of payment. So it's a combination of having a place, a platform, a location, an online presence whereby products can be sold, products of third parties, and payments can be accepted and processed. Essentially, business can be transacted. And so a marketplace facilitator, when you look at it at that level, is not that difficult to achieve in the way of a business description. That being said, what happens in the world of technology is there's businesses that operate their own websites. They're not marketplace facilitators because they're not inviting third parties to participate in those transactions. So they kind of stand on their own. They will establish nexus through their economic standards or presence, maybe some physical presence. So we are talking about some of the more well-known platforms that we're all used to seeing. But what states have simply said is, if you are a marketplace facilitator, if you meet the definition of a marketplace facilitator, you have a similar requirement to comply with the sales and use tax laws on all transactions that go through your platform. And the economic standards that apply to Wayfair also apply to the marketplace facilitators. They're essentially the same. And so the way to think about it is $100,000, just like we thought about it from a remote seller perspective. The migration, I'll call it, from the remote seller sort of establishing an economic nexus in a way that really required them to comply with sales and use tax laws, the migration to the marketplace facilitator was the high five, I think, for all the states. I think if they all were willing to admit it, it was really Amazon had been under their skin for so long. But the reality is, once these states, by the time they all got to this marketplace facilitator legislation, Amazon was already complying everywhere. They were already filing virtually everywhere. There were a few holdout states that they hadn't signed up in. So it really wasn't as big a deal or as big a commotion at that level as we might have thought it would be. But as everybody, I think, can relate, and we've talked, and I've used Amazon. I hope I'm not sounding like I'm picking on Amazon. Amazon's just the elephant in the room, so to speak. But these examples of Amazon, eBay, Etsy, Wayfair, they are examples. Anybody that has the platform that allows a third-party product, service element to be sold on it and payments are collected, they'll be considered marketplace facilitators.
Yeah, and just to kind of reiterate, one of the points that Jeff made is that I always like to see how these rules and laws kind of change over time and develop. So we had these economic nexus rules that came into place post Wayfair, and with the idea that these remote sellers that are selling on some of these, I'll call them platforms, because at that time we didn't have that marketplace facilitator definition. But the idea was for these remote sellers to now have the obligation to collect and remit the sales tax. But what was happening is there's so many of these remote sellers that are selling on these platforms that the states couldn't get their the revenue that they wanted. They couldn't get to the sales tax collection. So they kind of elevated it and said, okay, now we're going to make these marketplace facilitators collect. And it was something that, I don't know, maybe trailed the economic nexus standards by 6 months to 12 months. It didn't.
Yeah, that's probably fair.
Didn't take the states too long to catch on that there was a gap there.
The other thing I think that's sometimes lost in this equation, again, kind of revisiting the standard of physical presence, is warehousing. When I described what a marketplace facilitator was, you didn't hear me say fulfillment. I described facilitating through an online platform, and I described accepting and receiving payment. But fulfillment is not necessarily a requirement for for a company to be a marketplace facilitator. That being said, we all recognize that these names we just mentioned earlier are doing quite a bit of fulfillment. And in doing so, what happens is they'll take inventory that is actually the property of another company, they'll put it in their warehouse, and they'll actually move it from warehouse to warehouse. They'll actually one day have it in a warehouse in Georgia, and the next day they've decided we're getting more business activity out of Columbus, Ohio. We're going to move everything to our Cincinnati warehouse. We got some real-time deliveries we need to make there. So that inventory being located and housed in a particular state generally and historically would give a company nexus. And what was really challenging in the early 2010, 2011, 2012 timeframe was that Amazon having these warehouses pop up everywhere, knowing they were moving inventory from place to place, really caused a great deal of concern to a lot of folks that were selling through those platforms. This was before those platforms were charging tax, and what they were doing was making the sales. They were still applying tax or calculating, but the tax responsibility was back to the original seller, the vendor on record. And so these inventories being moved and located all over the country was giving these companies physical presence, and they had no idea they had it. They didn't know. They didn't have control over those inventories. What's happened more recently is that the states now will look at those sort of circumstances, especially now that they have the marketplace facilitator rules in place. They can be a little more lax. And what they tell companies is if you don't control the inventory, if you're not dictating where that inventory is located, then that inventory that's managed by the third-party fulfillment, or in this case, a marketplace facilitator, isn't necessarily going to create physical presence or nexus. So,
sorry to interrupt. I'll just comment on that as well, because I think Pennsylvania was the most recent example of that. I forget if it was an actual court case or how far up the food chain it went, but I think it was as recent as the last week, maybe the week before, that Pennsylvania said that if the only nexus creating activity you have is inventory in these warehouses, then in their opinion, you do not have sales tax nexus and do not have the necessity to collect the applicable sales tax. So I think we're going to see more states that follow Pennsylvania, and we'll see that over the next, I'm sure, several months or so.
Yeah, we had it happen in an audit where the state of Illinois attempted to require local tax collection. And I won't go into the complexities of that matter, but they claimed that because Amazon, in this particular case, was inventorying our client's product in the state of Illinois, that when they sold to customers in Illinois, they were required to apply the local tax. This was before the marketplace facilitator rules, and our client was actually responsible for the tax. Amazon was handling the collection. And we did have some dialogue back and forth, ultimately pointing to administrative policy of the state of Illinois that specifically said the same thing Brian just described in PA. So long as the fulfillment is provided and performed by somebody that has complete control over the inventory, the vendor ultimately in that case was not liable. So warehousing is still a thing. It's still a challenge. And I think what you're starting to feel, my guess, is that this gets more and more complicated every time we switch a slide. There's just another level of complexity, another level of, and I think that's true to some degree. It takes a little bit of time and a little bit of getting used to. I think what we're trying to do in this particular case is give you the broad spectrum, the big picture across all the states and across all the scenarios. When you get back into your business model, if you're a remote seller, that's a term that's used in this sort of economic nexus world. But if you are a remote seller and you are using a marketplace facilitator, you can get very specific about your specific circumstances and simplify this particular debate and discussion. So I don't want anyone, I'm sure that some of you may or may not find it complex, but if you are finding it complex, there's an easier solution than what you might be thinking. So that kind of brings us to, what do businesses need to do? What do we recommend companies do? If you are in a business that is leveraging a marketplace, you're selling and making a big business push in that regard, it's important to understand that there are some specific reports that will be available to you from that marketplace. They usually are available on a monthly basis. They're probably available real time. You should be gathering that data on a monthly basis. You should be evaluating your channels. If you are operating with multiple channels and you have your own website, you need to understand that those sales going through the marketplace facilitator in some states could be creating nexus for you, and that your sales through your own website therefore could be subject to tax. So it's important to consolidate all of that sales activity and evaluate it periodically. It doesn't mean you have to look at it every week, every month, maybe once a quarter if you're in a fast growth or fast-paced growth. Slower paced growth, maybe 6 months or even annually. Just take a look. Don't let it get too far out of control before you have an opportunity to take some level of action. The other thing that's a little bit complicated is dealing with exemptions. Exemptions through the Marketplace Facilitator platform are complicated because who do we issue the exemption certificate to? Do we issue it to Amazon, or do we issue it to Amazon Fulfillment by Amazon for ABC company? Generally speaking, if it's Fulfillment by Amazon through an ABC company, if the ABC company is effectually the vendor of record, the exemption certificate has to be issued to ABC company, even though Amazon is the one collecting and remitting that tax. So that gets a little confusing and complex. And then understanding when and where registration is required. Timing's everything. The sooner you can get yourself in a position where you're passing that sales tax burden on to your customer, which is the intent of sales and use tax, for the end user consumer to really have the responsibility of that tax. The sooner you get there, assuming it's a necessity, the better off you are. And it brings with it a number of headaches. We recognize that. But there's headaches one way or the other. I think sometimes the cost of compliance is dwarfed by the risk of noncompliance. And so it's just important to understand the scope of that for your own business. What else is there out there? I thought I'd share with you just a couple of things that we've talked about recently. I had a conversation with the state of North Carolina. I wasn't sure I'd talk about this today. I didn't get a whole lot of clarity, but one of the things that we're talking about and dealing with is companies that they kind of look like a marketplace facilitator. There's a lot of companies out there that have software applications that are supporting a shopping cart within an internet platform, like a Shopify. And while I don't know that Shopify accepts payments, so therefore doesn't necessarily fit into the definition of marketplace facilitator, there are companies that are kind of crossing that line. They have the software application that's facilitating the cart, and they also are incorporating the payment. By law, in a lot of ways, the way the statutes are reading, they qualify or could be characterized as a marketplace facilitator, even though there isn't a marketplace owned or controlled by them. They're just software that's getting attached to the website of, let's say, TaxConnex. So if we decided to start selling books through our website, we might need to engage a third-party software application, and we need for that application to encompass both the ability to have a cart and take the order, as well as accept the payment. So what is that? How does that fit? Is that a marketplace facilitator? Or am I still the vendor of record and I still have the responsibility to register, charge, and collect? There are circumstances that are happening right now, and this is an evolution, where companies are in that position. They're not quite sure which side of the fence they sit on, and it's important to know. what they're doing is voluntarily going to states and entering into agreements to be considered a marketplace facilitator, even though they're not quite sure they meet the definition or they might not meet the definition. The confusion that exists around all of this is such that it's just easier for them to go ahead and be a marketplace facilitator, and it's easier for them to sell their customers products. It's easier for them to get a market established and earn revenue. So there's some of that going on. North Carolina is not engaging in anything like that at the moment, but they are aware that there are some states that are engaging in that. I think it's important to distinguish between whether or not the marketplace facilitator owns and operates the marketplace, the platform, the website, versus the brick and mortar store or the remote seller owning and operating the website and just using those tools to make and facilitate the cart transactions and the payments. It's a fine line, and we're challenged with it. We're still trying to figure it out. It's still evolving. I worry a little bit that the states can take advantage of some of this, because to the degree that I establish myself as a marketplace facilitator and I charge the tax on behalf of my third-party seller, and I report that tax and pay it to the state, well, 4 years from now, the state could knock on the door of that third-party company, that mom and pop that was trying to sell through Amazon or through another marketplace facilitator, and say, we don't think you were selling through a marketplace facilitator. We don't consider what that company was doing to meet the definition of marketplace facilitator. So while they did collect and pay the tax, they shouldn't have. You still owe the tax, and we're going to come back and seek it from you. That's the thing that's gotten on my mind of late, and we're trying to kind of work through that. So there's still some evolution that needs to happen. Again, if you are operating through a marketplace facilitator, make sure you're getting reports adequately every month. Keep those reports. Let's not assume they'll always be available for you historically. There are a number of different things, moving parts and different scenarios that exist in this marketplace facilitator model. And states like Illinois, Louisiana, there's some unique rules and functionality that has to be understood there. So, we're happy to take on any questions or circumstances you guys may have on a offline basis to see if we can clarify or help you out with any of that. Thank you.
This has been It Depends, with another episode explaining the complexities surrounding sales and use tax. We'll see you next time.